Welcome back my YouTube channel NDS Shorthand. Please like, share and don't forget to subscribe the channel. 5 seconds to go. Start. The second point on which considerable controversy was raised before us related to the scope and ambit of Section 165 of the Indian Penal Code. I agree with my learned brother that it may not be desirable at this stage to refine the precise ambit and coverage of Section 165 because that is a matter which will have to be considered by the High Court in depth when the case goes back before the High Court and the first respondent is called upon to face his trial on the charges framed against him. But it is necessary to indicate the broad parameters of Section 165 and to emphasize the basic distinction which exists between that section and Section 161. It may be pointed out straightway that these two sections have been enacted by the legislature with a view to eradicating corruption in public life. We may usefully quote here the following pertinent observations made by this court in Revision Special Courts Bill, which came by way of presidential reference and which reported in 1979 within bracket 2 SCR 476 within bracket AIR 1979 SC 478. As I read it, this measure is the embryonic expression of a necessitous legislative project, which, if full-fledged, will work a relentless breakthrough towards sketching through the compulsive criminal. In any case, in Gujarat, decision itself clearly lays down that even if Section 12 is held not to apply to an application under Section 25 of the Act, the court must be held to have inherited powers to make such an order pending the decision of an application filed under Section 25 of the Act. It was observed in that decision at page 228 of the report. The question would, however, still remain whether the petitioner was entitled to maintain the application for interim custody of Narmada under the inherent powers of the court. I do not agree with Mr. R.C. Mankart that the court has no inherent powers to make interlocutory order for interim custody of a minor apart from the express provision of Section 12. It is no doubt true that since there is an express provision contained in Section 12 for making of interlocutory order for interim custody in an application for appointment or declaration of a guardian, the inherent powers of the court cannot be invoked for making any order for interim custody in an application for appointment or declaration of a guardian. The enactment by the legislature of an express provision would exclude the inherent powers of the court in the area over which the express provision operates, but when the question arises whether interlocutory order for interim custody can be met in a position under Section 25, to which the provisions of Section 12 do not apply, I do not see how the inherent powers of the court can be excluded. If the court can under Section 25 order that the minor should be returned to the custody of a guardian on the ground that it is for the welfare of the minor to return such custody, I do not understand why the court cannot do so as an interim measure. It may take considerable time before a petition under Section 25 may be disposed of by the court, and if the court has no power to make interlocutory order for interim custody of the minor, considerable injury may be caused to the interests of the minor during the period that it may be taken to dispose of the petition. Surely the court is not so powerless as to prevent any injury being caused to the welfare of the minor during the period that the petition is not disposed of by it. I am of the opinion that the court has inherent powers to make interlocutory order for interim custody of a minor in a petition under section 25. This being the position, it is obvious that the application of the petitioner for interim custody of Narmada was maintainable under the inherent powers of the court. With respect, I completely agree with the law laid down in the passage quoted above. In the premise, I hold that the impugned order does not suffer from any error of jurisdiction warranting interference by this court under section 115 of the Civil Procedure Code. On merits, I endorse the conclusions reached by the court below that it is a fit case in which an order should be made for the return of the child to the custody of the mother. The discretion exercised by the court below is valid and proper. As a result, the revision fails and is dismissed with cause. The interim orders passed by this court from time to time are vacated. Revision dismissed.